SJC-13685, Trustees of BU versus Clough Harbour Associates, LLP.
Okay, Attorney Sullivan.
Good morning. Madam Chief Justice, may it please the court, Michael Sullivan with my colleague William Burke for the Appellant, Trustees of Boston University. The trial court entered summary judgment against Boston University and its indemnification claim. It did so based upon the statute of repose, Section 2B. The statute of repose is directed to tort actions. BU's claim is a contract action. We submit that the decision was an error and should be reversed. And I would point the court to three, I would submit compelling sources of authority for this conclusion: the parties, the legislature, and this court. The parties spoke to this issue through their contract. In a big construction project like this, the parties enter into a very detailed, lengthy, comprehensive contract.
Can I ask you a question? Is that a standard form contract, or was it one that was negotiated and changed?
The indemnification provision is from an AIA standard form, and I'm not aware of any changes to that.
And how, if at all, does that affect our analysis? Because one of the things that you focus on is the sophistication of the parties who are entered into this contract. But if it's a standard form contract, can you just explain how that affects the analysis, if at all?
Your Honor, there may be some contexts in which a standard form versus a more specifically negotiated agreement may be relevant, but we would submit that here, when you have these two sophisticated parties, the court should presuppose that these parties, who well understood their rights, who well understood projects like this, who have their own attorneys, understood every word in this contract, whether it was a standard form or not.
Excuse me, were there any findings by the lower court about whether this particular provision was negotiated between the parties or was part of the standard form contract?
There were not.
Because I looked at the contract, it's in the record, and I see that it's a standard form contract, but it also recites the beginning that where there's a left-hand line like this,
Yes.
that indicates that it was changed, sort of like track changes that we're familiar with, and there is a line next to this provision.
Well, Your Honor, what we're left with is the provision itself, what we were left with. I'm not aware of any specific change that's relevant to this issue. And what you're left with is this first-party indemnity provision, which is a relatively rare provision. Many cases, you just have a third-party provision or you have one of these act-based provisions. This is clearly a first-party provision that's never been disputed, and it's the only reflection of the party's intent. And that has to be honored by the court. The contract means what it says. And the parties could have used any predicate they wanted.
Can I just,
Yes,
I just want to follow up on the standard form a little more. So if this is the standard AIA form, so is the statute of repose going to disappear in every major construction project? because there's always going to be an indemnification provision to allow, I mean, I understand the purpose of the statute is to prevent torts, old torts from going forward, but if this is a standard provision in every construction contract, aren't we going to just turn them all into indemnification cases?
At the end of the day, I'm not aware of whether this particular iteration.
Looks pretty familiar.
It is, and I would try to point the court back to, obviously, the legislature has spoken, putting aside the party's intent for a second. There's multiple problems with a conclusion along the lines that Your Honor may be driving at. If you read other terms into the contract, that's a very slippery slope, this just idea that this is not a contract. This is really about the underlying concepts that are in the contract. And so if you determine that something else should be read into the contract that's not there, you're essentially rendering it meaningless, because if we are to say that this merely repeated the negligence rights that BU already had and the breach of contract rights that BU already had, it's meaningless. And we obviously have a longstanding principle against the idea of interpreting contracts as meaningless or superfluous.
It may not be meaningless, it just may be barred by the statute of repose, right?
it may not be infinite.
From a straight contract interpretation, I would suggest that it's meaningless or virtually so, because again, BU already had the right to do those things in the agreement.
May I ask you a question about the state of the record?
Yes.
There are, and really my question is driven by the language of section 10.10. So as I read this indemnification provision, there are two possible predicates. One is if the expenses, which is the language that you're relying on, are caused by the architect's failure to meet its obligations under this agreement, or by the negligence of the architect or the architect's employee or agents. Are you relying on both of those?
No, it's just the negligence portion.
Okay, because that's the only thing I saw in the complaint, where any factual allegations I saw in the complaint really were negligence allegations, correct?
That's correct.
And was there any discovery after that?
No,
So the state of the factual record are just the allegations of the complaint?
yes, there was no discovery to the question earlier
Or
on
even-
what went into the agreement, what the parties actually.
I'm not worried about what
Yeah.
went into the agreement. I'm worried about the cause of action itself, what you're claiming was wrong. What you're claiming was done wrong, though the only things we know about that are what's in the complaint?
Yes,
Okay, and those sound in negligence.
yes. And we submit that when the parties entered into this agreement, they essentially took the negligence right that BU already had and turned it into a contract right. They could have used any terminology they wanted, but if they used negligence versus act-based, or they could have limited to third party, the choice of the predicate in the agreement didn't somehow transform this contract right into a tort right.
But counsel, if the indemnification claim doesn't rely on proving negligence, what else is there in this case? Can you identify anything other than a scenario or some other scenario where BU could recover under the indemnification provision without establishing the negligence of CHA?
No, Your Honor, I'm not going to pretend that it's anything other than that.
Well, so then if you go backwards then and say that it's a slippery slope if we're looking at the gist of what we're talking about, why wouldn't this be properly subject to the statute of repose? Or one other thing, would it be different if the indemnification clause said that it applied irrespective of fault?
I think everyone is in agreement, CHA makes a point of this, that if you didn't use the word negligence, this would be an endless claim and it would not be subject to the statute of repose. And we're saying the fact that you use the word negligence, it's still a contract right, and it's the same result. This is a protective measure to CHA. We have to prove fault. We shouldn't have less protection. It's a contract right. And
Can you explain to me, so in Gomes, the case that you're relying on, the court looked at the gist of the claim as well. Why wouldn't we do that here?
In Gomes, and I don't want to take up all my time quoting case law, but if you look at Gomes, the court said, and this is a quote, "The gist of Pan Am's action is essentially contractual, the enforcement of a contract of indemnification." And they went on to say that in the Klein case, we left no doubt that Section 2B expressly provides a limitation only for actions of tort and does not apply to contract actions. 5 or 6 cases since then, including the recent Cianbro case from Justice Casper of the United States District Court, interpreted the statute of repose the same way. That was a statute of limitations decision, but I'd submit that Justice Casper's analysis, which followed the UMass decision, is consistent with Gomes.
Gomes is the only case, Gomes is the only indemnification case we have, right? All
From
the
this
other-
court, yes.
Yeah, from this court,
Can I
right.
ask you a question about a footnote in your brief? One thing that the indemnification provision purports to give to BU is not only its expenses, quote unquote, for negligence of CHA, but also attorney's fees, which under the American rule is not something BU would ordinarily get in a negligence action, even if BU prevailed. You have a footnote in your brief, in your reply brief, addressing the attorney's fees issue, and I on page 17, and I just truly didn't understand the footnote. Could you tell me what you were saying there about, you said that one cannot rely on an argument relating to attorney's fees, but I just did not understand.
I believe it was the advanced healthcare case where a party referred to, was trying to argue in the context of the statute of repose, a provision about attorney's fees giving the provision meaning. And what was said in that case is that indemnification agreements are not prevailing party attorney's fee provisions. They're indemnification agreements. They provide for all kinds of relief. They typically provide for attorney's fees. If the parties only intended to provide an additional right for attorney's fees, they would have just said that. The typical clause in that situation, not indemnity, a prevailing party provision to override the American rule, says if there's a disagreement under this contract, the prevailing party gets its fees.
So your point in that footnote and your point today is simply that one should not read this indemnification provision as solely providing a right to attorney's fees and not actually indemnifying with respect to expenses.
Exactly. You'd be ignoring the remainder of the agreement. And if I could circle back to...
Can I ask you one more question? Because I think they're going to get up. I take it your argument, Nolan's decision in Gomes is controlling. It's the only indemnification case, and it's indistinguishable. I think they're going to try to distinguish the language of the indemnification provision. Do you want to take a shot at saying it's the exact same language, or
it's not
the same?
It's not the exact same language. Mm-hmm. There actually are two predicates in that case, one of which was negligence, mm-hmm. the other of which was a more act-based. If there's a claim against us and it relates to your work, we can bring a claim against you. And CHA really focuses on, we'd suggest out of context, on the one sentence of Gomes where they say that the statute of repose does not bar an action founded on the indemnification agreement of the type in this case. If we were just dealing with that sentence, I might suggest that there's some ambiguity.
Well, that's what my question gets to, because the type, is the language essentially the same here? Because that's what I'm trying to understand, because I don't quite see the difference in the language in Gomes from here. I'm not sure Gomes is correctly decided, and it seems to be sort of inconsistent with a lot of things we say later, but it is on point for you, and I'm just trying to get a sense of whether the language is exactly the same.
It's on point in terms of that agreement having negligence language. It also had act-based, so if you look in the footnote, the indemnification provision had two predicates, one of which was negligence. And the court didn't really discuss in the decision proper what aspect of the agreement supposedly took this out of the statute of repose. But as I quoted earlier, they went on to say in that subsequent paragraph that the gist of the action is contractual, enforcing a contract of indemnification. They quickly moved from that and referred to Klein and said the statute of repose does not apply to contract actions. And all the cases since then have said, one after the other, and up until the time of Cianbro, Gomes stands for the proposition, consistent with the language of the statute of repose, that contract actions are not governed by the statute of repose. Justice George, as you asked before about getting under the agreement to the gist of the action, and Justice Kafka, you mentioned some of the other cases. I just wanted to, the UMass case, I don't want to talk much about the UMass case. Obviously, this court's going to make its decision, but that's why we're here. That was the second summary judgment decision that came up in this case and that we're appealing from. UMass relied on two lines of cases. We suggest that they improperly conflated the different lines of cases, and this court has to send them back and correct that error. The Klein cases, not a contractual indemnification case. That's an implied, an effort to get around the statute of repose by calling a tort right a contract right. And the Bridgewood case that two justices on this panel, I believe, or three justices were involved in, that was trying to reconcile two different statutes. That also did not involve contractual indemnification. And I'm running out of time, Your Honor. The Gomes line of case is still good. It's still on point. All the courts have interpreted it the way that we do. And again, UMass sort of took us off on a detour, and we're suggesting this court has to bring us back on track. And I'd like to leave, Your Honors, with an example of the slippery slope element of this, that if we are to look past an agreement here and to talk about the gist, it's inviting parties. It eliminates this bright line rule that's created in Gomes that we think should be reaffirmed. If we're talking about the gist, then in this and other contexts, parties are going to be encouraged to say our agreement did not mean what it said. It meant this other thing down here in the gist. If you had a settlement agreement in a lawsuit with a non-disparagement provision, a party could say, well, non-disparagement is sort of like defamation. Let's look at defamation. That's really the gist of disparagement. You should have brought your claim within 3 years. That wasn't a contract right. And we'd submit that this court would find that that's a contract right, and we submit that this situation is really no different. The legislature made this public policy decision. They could change it. We submit that this is a conscious decision by them, and the parties spoke to the issue, and that nothing should be read into their contract.
Would this issue be avoided if the contract said, the indemnification clause said, notwithstanding, the statutory, the statute of repose, we will be indemnified, blah, blah, blah?
I think the court has two options. One is to, and CHA has raised this point that in order to get around the statute of repose, the parties have to specifically say that. I mean, again, under Gomes, this contract was signed. BO had every reason to believe that this was going to be enforced as a contract. You can contract around the statute of repose. The net case does not say you can't. And again, if the conclusion is the parties need to specifically mention that, that's again inviting people to say, well, bring these other words into the contract. The silence reflects the intention of the parties to not take this case out of the general rule that this contract claim is governed by the statute of repose.
Well, why isn't the general rule that this claim is a negligence claim, which is a tort claim, and if the parties want to get out of the statute of repose, they need to state so clearly?
Well, Your Honor, this goes back to your earlier question about Gomes, and this court saying 35 years ago that the gist of a contract indemnification claim is contract indemnification. It's not according to the underlying principles. The Klein doesn't apply. Bridgewood doesn't apply. The gist is bringing a contract claim, and that's not the gist of the action. Again, you're inviting these arguments that agreements don't mean what they say.
Okay, thank
Thank you.
Attorney Howard.
Good morning. May it please the court. Eric Howard on behalf of Clough, Harbour and Associates. With me, my colleague Sean Laughlin and Tom Duquette. This court should affirm the Superior Court's summary judgment decision for 3 reasons. One, BU is seeking an indemnification based solely on negligence. If BU wanted to incorporate an express warranty or a guarantee or the language that's in Gomes, they could have done that. Number 2, the Superior Court correctly held that the Gomes decision doesn't create a bright line rule that every claim for contractual indemnification is exempt from the statute of repose. And then 3, the Superior Court correctly applied the analytical framework that this court created, going back to the Klein decision and then Anthony's Pier 4. And the,
Go ahead.
No, you go ahead. Well, Klein specifically says that 2B does not apply to actions in contract, does it not?
I'm sorry, I missed the first, but Klein said...
Klein specifically says that 2B does not apply in actions in contract.
I'm sorry, 2B...
Klein has a line in it. I don't have the case in front of me, but it literally has a sentence that's section, the statute of repose in 2B does not apply to actions in contract.
Understood. Section 2B of the statute of repose. My reading of Klein is, one, it affirmed the constitutionality of the statute of repose, but also recognized that the statute of repose would not apply to a claim for an express warranty or guarantee. That is not something new.
The holding of Klein that's really important is that the Klein held that it does apply to an action for implied warranty, because the court held that the implied warranty is that is to say, the warranty imposed by law is the same as the negligence standard.
Correct.
So the court held, as a matter of common law, essentially, that where the implied warranty that pursuant to this court's holding was going to be the same as the negligence standard would blow a massive hole in 2B, to say. So that was the holding of Klein, and it expressly distinguished a contractual action where parties had agreed, had made promises to each other, either via express warranty or via contract.
Correct.
And then in Bridgewood, the court was dealing with Chapter 93A, which is a statute, and a tricky question where we had a statute from the legislature saying it is a per se violation of 93A to do this wrong thing, and then also we have a statute of repose applicable to tort actions, and do we or do we not apply that to a 93A action? So understanding the meaning of the legislature. Can you state your best argument for why, in a case where we're not dealing with the common law, this is not a common law question here, this is a question of whether to enforce a contractual promise, we're not, well, I guess this is a question. Is it your position that a party simply cannot contract around 2B?
No, that is not our position. I think that I'd go back to the Anthony Superior 4 decision, because I think that is factual analogous to this case, because you have an owner and an engineer similar to what we have here. And in that instance, the court found that because the engineer had made an express promise to the owner that this mooring system will not fail, even after the owner had said, I'm concerned about whether this is the structural integrity of this mooring system, and they said it doesn't need any additional structural support. That was, the court interpreted that as being an allegation and evidence of a warranty or guarantee.
It was a promise. The duty was imposed on the party by virtue of their own promises.
Correct.
And here you have a contract that promised to pay BU for its quote unquote expenses arising out of any negligence by CHA.
Correct, but there's nothing magical about an indemnification clause. It's really a risk allocation provision within the contract. And
well, it's a promise to pay BU's expenses of a certain kind, is it not?
But only if we're found negligent. Only if we're found negligent.
It doesn't say if a court finds you negligent. It doesn't say based on a judgment in a negligence action. It just uses the word negligence and says expenses, duty, or negligence, correct?
Correct. I would interpret the provision consistent with how I believe several courts have interpreted that the word negligence it's a legal term. It means that there's been an adjudication on the merits that someone has breached the standard of care. And therefore, that the indemnity provision under this contract would be triggered. And what the trial court determined here was, if this were to go to trial, we'd be having a trial as to whether or not Clough Harbour breached the standard of care, whether they were negligent.
So, but your argument would still hold even if the party said, if BU had chosen to say, if the parties had negotiated the contract that said, notwithstanding the provision of 2B and the statute of repose in 2B, CHA shall pay BU for its negligence. You would still have to have a whole trial about whether CHA was negligent, would you not?
I disagree. I think we'll just take the language in Gomes. If BU, and they could have taken the exact language in Gomes and incorporated it into this agreement, all BU would have to prove, like in Gomes, is to say, I've been sued, I've suffered a loss, and it doesn't require me to prove negligence. I can just show you, here's the loss I suffered. For example, like in Gomes, I've been sued, you have an obligation to indemnify me. That's a contractual promise that doesn't require a finding of negligence.
I was positing a provision that looks exactly the same as this. So BU can only recover based on the negligence of CHA. And then added to the provision is just a phrase, notwithstanding the 6-year statute of repose set forth in 2B.
Okay.
So is that a provision that the legislature has made unavailable to parties by virtue of 2B?
If I think I understand your question, you're getting to the point of, I guess, BU's argument that because we didn't expressly state that the statute proposed doesn't apply, therefore, this is a breach of contract claim. But I would go back to the agreement. The agreement does make reference to Massachusetts law. And then if you look in the agreement, there's a provision that says that Clough Harbour has to maintain professional liability insurance for 6 years after the date of substantial completion. That is the statute of repose. The parties clearly contemplated the statute of repose would apply, and the indemnity provision says there's 2 conditions by which you are entitled to indemnification. One, you have to prove we breached a provision of or an obligation of the contract. That's off the table. BU has acknowledged that. And then you get to negligence. And how do you establish negligence? You have to have a trial in the merits in terms of establishing. In this case, it would be, what was the standard of care for designing an athletic
But the
field?
elements of the contract claim are different than the elements of the tort claim. I know you're focused on one element of the contract claim, that is the breach, that is the negligence. But a contract claim requires an offer and acceptance, consideration, breach, and damages, whereas a tort claim requires a duty, and then there's the breach of that duty. So the claims, unlike the Klein claims, where the express warranty claim had the same elements as the tort claim, here the elements are different. Now you may concede there's an offer and acceptance consideration, but those are still elements of BU's claim. Why doesn't that take this contract claim out of the Klein express warranty type cases?
Because I
Or,
think
I'm sorry, implied warranty type cases.
this court has defined the analytical framework for how we interpret the statute of
Right, and the
repose.
gist of this claim, as your opposing counsel has said, is a contract claim. I'm looking at this contract, and Section 1010 tells me that I have this contractual right to indemnification that was offered, it was accepted, there was a payment made to CHA, and now, just on the breach element, I have to do the negligence part.
I guess I'm having trouble understanding, if this case were to go to trial, it would be a trial of whether or not Clough Harbour breached the standard of care.
Because you're not contesting that there's a contract, right? If you stood up and said there was never a contract, they'd have to prove that this Section 1010 that I'm looking at was actually entered into, negotiated, and that there was consideration for it. But by entering into that stipulation at the trial, it doesn't mean that those elements of the contract claim go away, whereas the implied warranty claim is entirely the same as the tort claim.
And I would, again, I go back to the only condition for the indemnity to be triggered is negligence, the tort claim. And this court has said we have to look at the gist of the claim. You can't just rely on the label attached to it. And I even go back, if you look at the Bridgewood decision, I would submit that the dissent in Bridgewood and the holding as to the issue of whether you evaluate a common law claim, for example, like negligence or a contract claim, that sort of analytical framework is the same. It hasn't, whether it was in Anthony's Pier 4, and I would say Gomes applied that analytical framework.
But I don't understand how, I have trouble with Gomes, because don't they have to do the exact same thing in Gomes? Like, look at the footnote 1 in Gomes, which describes the indemnification provision. It has 2 parts, including the negligence discussion. So I don't see, if Gomes is correct, I have trouble getting to, I don't know how you distinguish it on the language of Gomes. Tell me how,
So
let me just read it. The contractor shall indemnify and hold the owner from and against any and all costs, loss, or expenses, liability, damages, settlement, or claims for damages. Then it goes injury to persons or damages, including property, resulting from, and then go negligence. So isn't Gomes to recover in Gomes, they would also have to show negligence too, wouldn't they?
No.
Why
No,
not?
because Gomes had the additional language that's not in the contract here.
That additional, because I missed that. I just can't follow you.
Because in Gomes, the architect agreed that they would have an obligation to indemnify if there was an allegation, loss, and so all that requires is the owner says, I've been
It doesn't
sued.
say that. It says, all costs, loss, or expense, settlements or claims for damages. Isn't that fairly similar, if not almost the same as yours, because it's standard indemnification language?
No, I think it's significantly different, because again, if you look at the language in the indemnity in Gomes, it doesn't require any adjudication of the merits as to whether there was negligence. It only requires the owner to say, I've been sued, there's a complaint's been filed, in the complaint, and we don't know in Gomes, unfortunately, there's not a lot of
Isn't
factual
that the case
background.
in 1010? 1010 says demands.
I'm sorry?
Section 1010 indemnifies for demands, so why isn't that the same thing?
Because then you have to read the rest of the provision. It says, to the extent caused by, so a demand caused by your negligence. That requires you to prove your negligence before we're obligated to indemnify you for a demand. That's different than what was in Gomes, where they said, we've been sued. In the complaint, there's an allegation that somehow the slip and fall resulted in the design or construction of the project. We don't have to do anything else. We can just show you we've been sued, and by virtue of that, your indemnity obligation's triggered. It doesn't have us, we're not required to do anything else. In fact, you could say the owner could have moved for summary judgment based on those facts in the language in the contract.
But isn't it strange that the court in Gomes didn't carve out the negligence part? If in fact there was such meaning as you're putting into the actual indemnification, wouldn't you have expected the court to have said, all right, the negligence part, that one's within the statute of repose, but look, this contractual claim is actually broader, and so that's the part that's being enforced here.
But I think that's the significance of Gomes in terms of the narrowness of the holding, because the court didn't need to get into the negligence discussion. Where the court said, you know, an indemnity provision of the type here, or I mean, they were very specific. Because there was this particular indemnity provision, that's why we're saying it's outside the statute of repose. It doesn't require any other condition other than we've been sued. That's it.
Counsel-
And so it's a narrow holding. Yeah.
I'm still troubled by your earlier answer to Justice Wendland's question. You started your presentation by saying that an indemnification provision is simply a risk allocation provision. So is it at all possible for this to be contractual in nature, even if negligence is the triggering event?
I would say no, without any additional language. I mean, this, you know, going back to one of the questions during my brother's argument, this contract is a form agreement, but there was numerous revisions. And I would submit, if you look at the indemnity provision, this is a very narrow indemnity provision for a reason. The recognition of what occurred in Gomes and understanding Anthony's Pier 4. And that's why these contract provisions are negotiated to make sure that there is, you know, from our perspective, we're only obligated to indemnify if we're found negligent.
So what you're, I'm sorry, Justice Kafker.
I just want to make sure, and I'll defer back to you. So this isn't a standard AIA provision, or it is a standard AIA provision?
The contract is a standard form of agreement, but
Indemnification provision,
was negotiated, because if, to the point earlier by Justice Dewar, you can tell that it was revised or negotiated because of the black line on the left-hand margin.
but when I go and collect the standard AIA construction contractor, I'm not going to find this provision in it. This is
Not-
going to be sui generis.
Correct. This particular indemnity provision was negotiated by these parties. It's not identical to what you see in the form agreement.
And whether it's not the standard provision are two different things. Is this, again, are we going to find this is the standard big construction project provision for indemnification? I just don't know the answer to that anymore. At one point I did, but I don't know now.
No, in the sense that the standard form of agreement does have additional language. For example, typically we'll say any errors, omissions, acts, et cetera, to the extent caused by the negligence. So that added language, phrase that's in the sort of the unmodified standard form of agreement is not in this contract for the reasons that I've discussed. In other words, we're only obligated to indemnify if we're found negligent because we're mindful of the statute of repose. And Justice George, I don't know if I answered your question.
No, Chief, may I just one? So I just want to make sure I have this right. So would your position have changed would be changed on the indemnification clause if it didn't reference negligence and simply required indemnification for any costs that were related or incurred as a result of CHA's performance?
I would say we would have a very difficult argument to distinguish that situation from Gomes.
Thank you.
For those reasons, I ask that you affirm the Superior Court decision. Thank you.
Thank you.